Namaskar, and a very pleasant morning to everyone present here for the inauguration of Vulnerable Witness Deposition Centers, virtual courtrooms, and e-filing stations in district court complexes in the state of Orissa, and the one-day training workshop on the functioning of the Vulnerable Witness Deposition Centers organized by the High Court of Orissa, Cuttack, at the Orissa Judicial Academy, Cuttack. We are honored to have amongst us Honorable Shri Justice L. Nageswara Rao, Judge, Supreme Court of India, Honorable Ms. Justice Gita Mittal, former Chief Justice, High Court of Jammu and Kashmir, and present Chairperson, Vulnerable Witness Deposition Centers Committee, Supreme Court of India, the Honorable Chief Justice, High Court of Orissa, and all the Honorable Judges, High Court of Orissa, both present here and joined through virtual mode, and the respective resource persons of this workshop. I humbly request His Lordship, Honorable Shri Justice L. Nageswara Rao, Judge, Supreme Court of India, to kindly adorn the dais, and I request the esteemed Registrar General, Shri Chittaranjan Das, to kindly conduct His Lordship to the dais. Thank you. May I humbly request Dr. Justice S. Muralidhar, the Honorable Chief Justice, High Court of Orissa, to kindly adorn the dais, and I request the esteemed Director, Orissa Judicial Academy, Shri Gauri Sankar Satpathy, to kindly conduct His Lordship to the dais. Thank you. May I humbly request Her Ladyship, Honorable Ms. Justice Gita Mittal, former Chief Justice, High Court of Jammu and Kashmir, and present Chairperson, Vulnerable Witness Deposition Center Committee, Supreme Court of India, to kindly adorn the dais, and I request the esteemed Registrar Judicial, Shri Suman Kumar Mishra, to kindly conduct Her Ladyship to the dais. Thank you. May I humbly request His Lordship, Honorable Shri Justice Bibhu Prasad Rautray, Judge, High Court of Orissa, and Member, Vulnerable Witness Deposition Center Committee, High Court of Orissa, to kindly adorn the dais, and I request the esteemed Registrar Vigilance, Shri Akhil Kumar Paschimakabat, to kindly conduct His Lordship to the dais. May I seek the permission of the Chair, Honorable Shri Justice L. Nageswara Rao, Judge, Supreme Court of India, to declare the event open. Thank you. The event is declared open. As a mark of our heartfelt gratitude, we would like to present flower bouquets to our honored dignitaries on the dais by the judicial officers of State of Orissa. So I request Madam Chinmay Dehuri to kindly present a bouquet to His Lordship, Honorable Shri Justice L. Nageswara Rao, Judge, Supreme Court of India. Thank you. I now request Madam Ranjita Jyotishi to kindly present the bouquet to Dr. Justice S. Muralidhar, the Honorable Chief Justice, High Court of Orissa. Thank you. I now request Madam Sarojini Pati to kindly present the bouquet to Her Ladyship, Honorable Ms. Justice Gita Mittal, former Chief Justice, High Court of Jammu and Kashmir, and present Chairperson, Vulnerable Witness Deposition Center Committee, Supreme Court of India. Thank you. I now request Madam Rashmita Sahu to kindly present the bouquet to His Lordship, Honorable Shri Justice Bibhu Prasad Rautray, Judge, High Court of Orissa, and Member, Vulnerable Witness Deposition Center Committee, High Court of Orissa. Thank you. Beginning with the inaugural session, I humbly request His Lordship, Honorable Shri Justice Sangam Kumar Sahu, Judge, High Court of Orissa, and Chairperson, Vulnerable Witness Deposition Center Committee, High Court of Orissa, who has kindly consented to join us by virtual mode to present the welcome address in this August gathering. Your Lordship, please.
Namaskar. Good morning. Honorable Justice L. Nageswara Rao, Judge, Supreme Court of India, my Chief Justice, Honorable Dr. Justice S. Muralidhar, Honorable Mrs. Justice Gita Mittal, former Chief Justice, Jammu and Kashmir High Court, and presently Chairperson of Vulnerable Witness Committee constituted by Supreme Court of India, my brothers and sister judges of Orissa High Court who are present here and also online, Learning Registrar General, Orissa High Court, and members of Registry, Director, Orissa Judicial Academy and his team, Learning Judicial Officers of the state from the cadre of Orissa Judicial Service and Orissa Superior Judicial Service, all the judicial officers watching this program online, Learning public prosecutors who are participating in the program, Learning Advocate General, Assistant Solicitor General, Learning Vice President and other executive body members of High Court Bar Association, 3 lady advocates, Mrs. Biva Datta Makhija, Senior Advocate, Supreme Court of India, Mrs. Vrinda Grover, Advocate, Supreme Court of India, Mrs. Gita Ramasheshan, Advocate, Madras High Court, who are the resource persons for today's training workshop on functioning of vulnerable witness deposition centers, officers of the government and distinguished guests, members of print and electronic media, ladies and gentlemen. I, as the chairperson of BWDC Committee, High Court of Orissa, along with the members of the committee, my esteemed brothers, Honorable Justice B.P. Rautray and Honorable Justice R.K. Patnaik, welcome all of you to the Millennium City of Cuttack and to this very beautiful Chief Justice Gati Krishna Mishra Auditorium of Orissa Judicial Academy. Much prior to the pronouncement of the judgment by the Honorable Supreme Court in the case of Smruti Tukaram Badade versus State of Maharashtra, my Chief Justice had a dream to have vulnerable witness courtrooms in different districts of our state, like Saket and Karkaduma court complexes of New Delhi. Walt Disney said, if you can dream it, you can do it. He took the initiative, and with his effort, the dream came to reality. A new district court building at Bhadrak was identified as the first court hall for vulnerable witnesses, and with the active cooperation of the state government, it was completed and made functional on 18/12/2021. Similar court hall was also inaugurated in the new district court complex in Malkangiri on 28/12/2021. There was interaction with district judges for construction of similar courtrooms for vulnerable witnesses, and then the judgment of the Honorable Supreme Court was rendered in Smruti Tukaram Badade case on 11/1/2022. My Chief Justice constituted a permanent committee on 19/1/2022 as per the judgment, and we proceeded to meet the necessary compliance and implementation of the direction made in the judgment. Then there was a meeting of the district judges of the state along with the executive superintending engineers of the respective R&B division as well as chief engineer building. The High Court of Orissa Vulnerable Witness Deposition Center Scheme 2022 was drafted, and after the full court approved the same, it was notified and it came into force on 9/3/2022. On 2nd April 2022, Honorable Justice D.Y. Chandrachud, Judge Supreme Court of India, inaugurated vulnerable witness deposition centers in 13 districts. Those are Cuttack, Angul, Balangir, Jagatsinghpur, Kalahandi at Bhawanipatna, Kendrapada, Koraput at Jaipur, Nayagarh, Nabarangpur, Nuapada, Sambalpur, Shonpur, Khurda at Bhubaneswar. So far as the rest 15 districts are concerned, we proceeded with the work, and again, with the active cooperation of the government and the engineers, the learned district judges, we are able to complete the vulnerable witness deposition centers in those districts, which are going to be inaugurated today by Honorable Justice L. Nageswara Rao, Judge, Supreme Court of India. The districts are Balashore, Bargarh, Baudh, Devgarh, Dhenkanal, Gajpati at Parala Khemudi, Ganjam at Barhampur, Jajpur, Jharsuguda, Keonjhar, Mayurbhanj at Baripada, Fulbani, Puri, Rayagada, and Sundargarh. We sought for monthly data from the 15 BWD centers regarding their performances, which they are to give to the committee by 5th of each month. And as per the monthly data of April 2022, in the 15 districts, 60 vulnerable witnesses were examined and 136 witnesses were examined in virtual court. The momentum will definitely go on, and all the 30 centers in the 30 districts will be fully utilized in future by different courts in dispensing justice to one and all expeditiously. The resource persons who are present here with us in this one-day training workshop are very experienced, and they in their respective session will not only highlight about the topics chosen for the session, but also clarify the doubts of the participants on any of the issues relating to the functioning of these centers. I hope all the judicial officers to utilize this opportunity and actively participate in the workshop. Please put your questions, clear your doubts, so that you will guide the other judicial officers of your respective districts in the functioning of BWDC. We propose to organize such training programs in future also, and we have also planned to open such centers in periphery courts where additional district judge courts are functioning. I hope this one-day training workshop will be immensely beneficial to one and all. Before parting, I thank Honorable Justice L. Nageswara Rao, Judge, Supreme Court of India, Honorable Mrs. Justice Gita Mittal, and the 3 lady advocates who will act as resource persons in different sessions in accepting our invitation, visiting the land of Lord Jagannath, and giving their valuable time for the noble cause. Thank you. Jai Hind, Bande Utkal Janayan.
Thank you, Your Lordship, for the warm welcome extended to our distinguished guests and esteemed participants. With immense pleasure, may I now humbly request Her Ladyship, Honorable Ms. Justice Gita Mittal, former Chief Justice, High Court of Jammu and Kashmir, and present Chairperson, Vulnerable Witness Deposition Centers Committee, Supreme Court of India, to kindly address the gathering in this inaugural session. Madam, please.
Justice Nageswara Rao, Judge, Supreme Court of India, my very dear brother, Chief Justice S. Muralidhar, Justice S.K. Sahu, Judge and Chairperson, BWDC, High Court of Orissa. I'm very sorry that you're not able to be here with us in person, and I wish you well, a speedy recovery. Sister and brother judges of the High Court of Orissa, sister and brother judges of the Judiciary of Orissa at all levels, Gita Ramaseshan, Brinda Grover, and Vibha Datta Makhija, resource persons at today's training, and my very dear friends. As has been our tradition, I have addressed them in not the order of seniority, but the order of, yes, the order of seniority. The director and faculty of the Judicial Academy, law officers of Orissa, office bearers and members of the bar in all the bar associations in Orissa, officers of the government of Odisha, staff of the registry, the wonderful members of the vulnerable witness deposition committees of all courts in Orissa, very ably led by a very dynamic committee in the High Court. A very, very good morning to all of you. Access to justice, a human right, also recognized as a fundamental right under the Constitution of India. Thank you, Vita. I think that's better. It's not easy to speak to a piece of wood in front of you. So, as I was saying, access to justice is basic to the rule of law. That procedure is important to justice delivery is encapsulated in the phrase, procedure is the handmaid of justice. It is well settled that equal access to the legal system is not about putting everyone through the same procedure, but it is also about designing procedures that accommodate special factors such as risks, harms, secondary traumatization, disability, etc., to enable a meaningful participation of special groups. This is essential not to enable not only equal outcome, but also for the dispensation of justice. Judicial systems are preoccupied with the innocence of the accused as well as the development of the adversarial system, where the public represented by the state is pitted against the accused represented by the defense. This system, therefore, completely fails to include any consideration of the victim or the witness or the needs and interests these persons have in the criminal justice process. Clearly, it is this a statement of the obvious if I would point out that there has actually been a historic neglect of the rights of witnesses as well as victims of crimes. So far as the criminal justice system is concerned, a uniform procedure for trial of all offenses and examination of all victims or witnesses does not necessarily result in equal access to justice. Rather, it may severely impede the same, especially in cases concerning sexual violence. This becomes worse where the victim is the witness as well, especially in cases of sexual violence and other heinous crimes. Judicial pronouncements as well as literature abound on the aspect of secondary traumatization of victims visiting the foreboding court environment, as well as in having to recount their experience in courtroom depositions where they have to stand shoulder to shoulder with the very perpetrators. There is a unique challenge in recording the testimony of a victim of sexual violence. The witness is required to depose about the violence to his or her most intimate body parts. Most persons find it difficult to discuss issues involving sexuality in the open. A victim who is recounting probably the worst kind of violence to her or his person and mind is expected to speak about the same to complete strangers, not only in an environment which is alien, but which may even be hostile. The traumatization of a victim is therefore compounded as the victim is completely without support in the alien courtroom where men outnumber women, and more importantly, because of the presence of the accused person. Statutes have attempted to provide shields, I would say even judicial pronouncements, in the nature of camera trials, as well as segregation of the victims by use of screens, etc., in courtrooms. This, however, has been found to be completely insufficient. What does such a witness do if his or her testimony is not completed in the pre-lunch session when it began? Where does such a victim go if he or she has to wait for the case to be taken up again after lunch? Sending such person into the public area may have exposed him or her to the accused as well as pressures from such quarters. It needs no elaboration that the purpose of recording witness testimony is to provide the court with such information which will enable the court to ascertain the truth and take a decision on the matter before it. Such information must be extracted from the witness in its most accurate form while ensuring that the distress to the victim is minimized. Bentham has said, witnesses, after all, are the eyes and ears of the court. By our small initiative in setting up VWDCs, it is all this as well as pain, insecurity, and trauma which we have tried to mitigate. The vulnerable witness deposition complex is a real-time instance of judicial intervention and judicial leadership to adapt procedure in the criminal justice system, addressing several barriers to the effective participation in trials of victims and witnesses of violence and facing the other barriers such as disability, threat from the accused, etc. VWDCs make actually a balance, strive to make a balance between witness protection and fair trial while ensuring access to justice to the victim as well as witnesses. Available material, simple technology, and minor modifications to available courtrooms make it possible for witnesses to testify on a video link. An option is given to the witness who, if desirous of deposing in the court, requires the judge to move the accused to an adjacent room with a one-way viewing glass so that the accused can view and hear the court proceedings. We have provided an audio link to him or her so that he can give confidential instructions to the defense lawyer. Despite the separation, the VWDC thereby enables the witness to remain visible and audible to the defense and the accused at all points of time. Thereby, there is compliance of the constitutional and statutory mandate that a criminal trial must be in the presence of the accused. At the same time, we have safeguarded the sensibilities and the trauma of a victim and a witness. As a manifestation of this sensitivity of the judiciary, the first of such facilities in India, probably in Asia and Africa, was inaugurated as back as on the 16th of September 2012 in the Karkaruma District Courts Complex, Delhi. I may point out that this was much before the 16th of December 2012 gruesome gang rape of Nirbhaya. It was certainly much before the issue of sexual violence started receiving media attention. This, I may give you a few historical back facts in this. In 2007 or 8, I had written a judgment, Virendra versus State. Those of you in the trial courts would be remembering this, which also changed the narrative about the linguistics of a trial. You know, buri harkate, galat kam was treated to be as a sufficient evidence of an act of rape having been committed. So the examination of the sensibilities of the prosecution, the investigating officer, etc., and the fact that there was no other evidence than other than this very superfluous statement, you know, was held that it could not be treated as evidence of rape. An examination of the several judicial precedents and the guidelines by the Supreme Court was undertaken in the same judgment. This led to the then Chief Justice A.P. Shah constituting a committee which I had headed and led to the designing of this first vulnerable witness courtroom in 2012 after a 4-year study of international best practices and visiting such courtrooms in other parts of the world whenever I had traveled. Now we were able to complete these courts in every district in Delhi, and more than 6,000 witnesses in Delhi have walked the path using this courtroom facility. I'm in the process of completing a film. There were minor mistakes and some portions weren't clearly visible. So the film should be ready by next week. I will be sending it to Honorable the Chief Justice, and hopefully each one of you will get a chance to see the experience. We have recorded bites of judges also who are working these facilities, you know, of some difficulties which you may come. Other difficulties we will address in the trainings which will go on. But actually how an existing courtroom can be transformed into a VWDC. You do not need space or budgetary allocation to raise new constructions of VWDCs. Therefore, to say that there's no space available, etc., is actually an anathema. You don't need new courtrooms. Very minor, and you have in the IT has so much property which can be used. You have audio and video devices. Simple LCDs are used to convert the room into a VWDC, which the film will show, since all of you would not have an opportunity to travel to Delhi and see how we have worked. The facilities have been designed keeping the psychological state of the victim in mind. The provision of a dedicated entry from outside from the building to these facilities enables the witnesses to stay away from the formidable court environment. We use the judge's entrance for enabling vulnerable witnesses to enter. In Delhi, we are actually picking up the witness. We send a court car with the support person to the residence of the witness to bring them to the courtroom, which further makes them feel safe. Initially, they are a little reluctant because when an official car comes to the community, other people also come to know about it. But this is only for the on the first occasion. The next time they want to bring relatives, etc., and friends to the courtroom, to the facility, to even show the sensitive treatment and the importance which is given to the witness. The testimony of the witness using these facilities stands transformed, the judges tell me. The witnesses have also been provided a facility to wait, if I may say so, to catch his or her breath before, during, and after making his or her deposition. And we also enable them to partake refreshments if she or he feels the need or has to stay back even after lunch. At the same time, sensitization of the judiciary, inculcating compassion in prosecutors, and developing more ethical defense lawyering is necessary to make the process just so that the resulting mosaic creates the necessary sensitized environment. There are several additional aspects which we shall discuss over the next few years. Establishing the infrastructure alone shall not suffice, and we shall flesh out the same by way of trainings to import the necessary sensitization to all stakeholders, which include not only the judges, but also the support persons, the prosecutors, the defense lawyers, legal aid lawyers, and most importantly, the police. The most important outcome, however, has already emerged. It is the realization of the judiciary and on our part that following universal procedures in all cases does not always result in justice. In Delhi, as well as in Jammu and Kashmir, we undertook extensive trainings of doctors as well, who conduct the medical examinations in the forensic aspects, as well as of 14 to 17-year-old school children who were not aware of the nuances of law. I personally went to schools in Delhi, the modern school, the schools run by government, NDMC, municipal corporation schools. We had reached out 400 schools by the time I left Delhi in 2018, telling children about the nuances of not only offenses like rape, but also a child will not be aware that in a simple insistence on dropping a, a friend to her residence, the child may have committed an offense of stalking. Children are also not aware of the implications of forwarding a ribald or a obscene WhatsApp message to other friends, for instance, you see. So this kind of lack of awareness needed to be addressed, and it was really an eye-opener, these trainings in both Jammu and Kashmir, we did it, and in Delhi. That today we are inaugurating the vulnerable witness deposition complexes barely after a few weeks after similar inauguration is testimony of the importance being imparted by the Chief Justice as well as the honorable judges to the project in Odisha. That a project in every district is ready is a matter of tremendous elation for me personally. I hope that traveling together in this journey, we are able to create comfortable and safe spaces where the dignity of vulnerable witnesses is maintained so that they are enabled to confidently testify and assist courts in the dispensation of justice in society, and justice is done to the victims as well. This committee has sent the prototype of the courtroom using the architectural design which is necessary. We have framed guidelines after a very elaborate confabulation of almost 3 months across the country, across the globe, in fact. The film is ready, a website is under development. The training module we already have, because in Delhi we trained over 650 judges, as many prosecutors, lawyers, in trainings which were conducted almost 14 times spread over 2 years. Now the module has to be adapted, keeping in view the recent legal developments and the jurisprudence which has emerged since then. But we also undertook sensitization. We had 2 sessions which we had labeled Voices from the Margins, in which we brought in representatives from the LGBT community. We had transgenders, we had lesbian and gay persons, we had a sex worker from Sangli, we had acid violence survivor. We brought in Suzette Jordan, a victim of gang rape, who had decided to disclose her identity and tell the courts, the judges, and the trainees about her experiences right from the time the crime happened, when she tried to report it, when a medical examination, the circumstance in which it was committed, the part of her statement is part of the film. She had given a declaration that she did not mind it being disclosed. And we will be using, she unfortunately died of meningitis before the order came, judgment came in her case. So while 3 of the accused in the gang rape got convicted for sentences up to 10 to 14 years, but those who were absconding have managed to go scot-free because she is not there to depose against them. But we look forward to, this committee looks forward to a very robust exercise of training. If one day may not be sufficient, we need to identify 2 days. And I think second Saturdays are holidays. I'm taking this information, I've requested the Chief Justices that second Saturdays are free, I think almost in every state, in every high court in the country. So we will be utilizing and trying to adopt a hybrid module, because the resource persons are also pan-India. We're trying to get in resource persons from other countries also, other experts where they have entrenched and developed systems. So the training module should also be ready before the end of the month, hopefully. My leaders in training, Gita Ramaseshan, Vrinda Grover are here. Vibha has joined our team as well. And we look forward to interacting more closely with you. My best wishes and congratulations to the entire court led by Justice Muralidhar, the entire team of the vulnerable witness deposition complexes, as well as the e-committee of the courts in Orissa, where you are now going to enable e-filing in the district courts. On the last occasion when I spoke, I had informed the gathering at on the 2nd of May function about an Insaf Ki Dastak project, legal outreach, a judicial outreach program of access to justice, enabling filing in post offices, in banks, in community service centers, after again an extensive training, and enabling joining remote areas and remote districts to tribals and areas which were cut off either by snow or by other topographic regions from the court complex. And simple templates were designed in the local languages. Kashmir had 4 languages. You have Ladakhi, you have Dogri, you have Kashmiri, you have Hindi, you have English. So we had designed templates, we had trained legal aid lawyers, we inaugurated this facility on the 7th of December, 2020. And unfortunately, COVID came and we couldn't run this program. Now, I think it must be reviving again. But these are initiatives, all on the initiatives on the part of the judiciary, not of the legislature, not of the executive, to bring justice to the doorstep of every citizen. I end with the hope that these initiatives in Orissa will truly be very, very successful initiatives. I thank the Chief Justice and all of you very much for enabling me to join and participate in this very important function, which marks, I think, the most important milestone which has been achieved today by the High Court of Orissa. Thank you very much.
Thank you, Your Ladyship, for highlighting the importance of upholding and protecting the rights of witnesses along with those of the accused to ensure actual justice being done. It is my utmost privilege to request Dr. Justice S. Muralidhar, the Honorable Chief Justice, High Court of Orissa, to kindly address this distinguished gathering.
Very warm good morning to everyone. Pranam. Justice Nageswara Rao, Judge Supreme Court of India. Justice Gita Mittal, my former colleague in the Delhi High Court, former Chief Justice of the Jammu and Kashmir and Ladakh High Court, and Chairperson of the Vulnerable Witness Deposition Courtroom Committee set up by the Supreme Court of India. My colleague Justice Rautre, all my colleagues from the High Court who are present here in the auditorium, and my dear colleagues who are present online, Justice Sahu and Justice Arindam Sinha, the Advocate General, the Assistant Solicitor General of India, all the distinguished persons who have attended today's inaugural, the dear judicial officers who have come in large numbers, the public prosecutors who are here, and of course, the 3 resource persons who've taken their time off to be with all of you. And I'll be speaking about them a bit later. I'm very happy that this morning has happened. It's just like Justice Sahu was mentioning, I have several dreams for the judiciary in Orissa, and this is one of those dreams. When I began, I said we should have one vulnerable witness deposition center at least in every district court. And today, when Justice Nageswara inaugurates the VWDCs, that would happen. That is, every district in Orissa will have one vulnerable witness deposition center. I had also said that every district court must have an e-filing station. And today, when Justice Nageswara inaugurates them, every district in Orissa will have an e-filing station. So these are initiatives that have been possible only because of the active cooperation of all my colleagues. They've all worked tirelessly day and night for all these events to happen. We've got committees formed, but they go beyond the call of duty. All of them are sitting up to 9:30 in the night, trying to dispose of the work of the administrative work of the committees. And literally it's a 24/7 judiciary working, not just in the High Court. If the High Court works 24/7, you can imagine the district courts. They're working perhaps even more if there is more than 24 hours in a day. So it's a coming together of a lot of minds. Like every time we have a function like this, and we've had several such functions where we're simultaneously inaugurating either court complexes or courts or centers, deposition centers or e-filing stations. A whole technical team comes together, led by the central project coordinator. They again work day and night. My registrars, I have an excellent team of registrars. Registrar General heads them. And they all don't look at, whether I'm Registrar Administration, he's Registrar Judicial, or he's Registrar Vigilance. They all participate. So it's really, for me, it's an eye-opener of how, when people come together, how much can be achieved. So a big thank you to all of you for making these events happen. The inspiration for the VWDCs came from Justice Gita Mittal's work. I always say this, in fact. In Delhi, she was a pioneer. She saw she had a vision for what should happen, why we were not succeeding in rape trials, how we were traumatizing the victim through the rape trials. And her persistent efforts saw literally state-of-the-art vulnerable witness centers in every district complex in Delhi. And I took a cue from that. We sent our officers to visit Saket, to visit Karkarduma. They brought back reports. We had Vishwajit Mohanty is here. He's now the secretary of the Orissa State Legal Services Authority now. But he actually he prepared a detailed report for us with photographs. He made presentations to the committee. And that's how these VWDCs started emerging here. We've also looked at the expanded definition of what is vulnerable. And we realized that vulnerable, even a witness who is, let's say, in a gang war, he's an eyewitness to a gang war. He could be under severe threat. So he could equally be a vulnerable witness. So our notion of vulnerable witness is also gained with the experience we've gained. We've learned to look at it in a broader perspective. So vulnerable witnesses could be any gender, any age, and it's about giving an assurance to the victim that the victim will be heard, the victim will not be threatened. We still are weak in the country on witness protection programs. And we have to support these VWDCs with witness protection programs. And that's where the state government comes in, their police force comes in, the ability to assess the threat perception of a victim, of a witness, and to give the adequate protection, not just during the trial, but very importantly, after the trial. We've had some very violent incidents in courts, not only in Delhi, even in Orissa, where witnesses are openly threatened, they're intimidated, they're shot at within courtrooms, attacked within courtrooms. So these are the new challenges that we face in the judiciary. And unless we have the active cooperation and support, not just of the administration, but of the bar, we will not be able to give the outside, the peripheral support that witnesses need, even to come to VWDCs. But this is a very, very important step that we are taking. In every court complex in Orissa, we want to even take it to outlying stations. There are a lot of criminal cases. In fact, the proportion of criminal cases to civil cases in Orissa, in Western Orissa, in fact, for every 8 criminal cases, there are 2 civil cases. So the proportion is almost 80:20. So in the Eastern Seaboard, of course, there are more civil cases, but a large number of courts in Western Orissa and Southern Orissa, the criminal cases predominate. And there, these kind of courtrooms will be playing a very critical role in bringing justice to victims of crime. The other important initiative that is being inaugurated today is the e-filing station. So we've gone forward with e-filing 3.0. Orissa is only the third state in the country to implement the e-filing 3.0 in the High Court, but the first in the country to implement it across all districts in Orissa. And we are facilitating that through these e-filing stations. But we're not stopping, and as Justice Gita Mittal was rightly pointing out, we're not stopping with just inaugurating these facilities. We're bringing everyone on board. Like today's participation of 15 public prosecutors in the workshop is very significant, because we realize that we have to train not only the bar, but the law clerks as well. So we've been doing these e-filing training workshops for lawyers and for clerks of lawyers, in literally teaching them how to do an e-filing. So it's a hands-on training. It's not just a video lecture or that kind of a training. Our master trainers sit together with the lawyers and teach them how to do the e-filing. So that has happened in the High Court, that has happened in the district courts, and it is not a one-off event. It happens periodically, once a month and perhaps once in 2 months. But this is a continuous effort we are making to bring the entire lawyers on board. And I must say that response of the lawyers has been tremendous, whether it's in the High Court or in the district court. We've always received cooperation from all the lawyers. So the third important initiative is the inaugural of what is called the Rail-Tel link, which is a parallel system of broadband connectivity apart from the BSNL system. So that will enhance the connectivity of courts. It will give them an alternative in case the network is not working properly. They can switch on to the Rail-Tel network. And that again, Orissa has made a big leap forward with that. And the last initiative is what is called the case law portal. We're creating a portal where judges who are now being given SEC online can post case summaries, which will help their colleagues. So we're hoping that they will help each other, and this will become a learning experience for all of them. Even they can post experiences like what they're going to have in today's workshop. I want to say one word about the 3 resource persons we have today. We are very, very fortunate to have the 3 of them here. What is special about Vrinda Grover or Gita Ramaseshan or Vivadatta Makhija, the 3 resource persons, is they're all active practitioners. They are actually hands-on practitioners in criminal law and civil law. They are in courts day in and day out. They've watched hundreds of witnesses. They've examined hundreds of witnesses. They've appeared before hundreds of judges. So they know what is courtroom tactics. They know how to handle a courtroom situation. They know about witnesses. They know about vulnerabilities. So when we pick up resource persons, we don't always get resource persons who are active practitioners, but I think you are the first workshop of BWDCs. You're very fortunate to have resource persons like these who bring together more than 2.5, maybe 3 decades of experience with them. So as Justice Sahu was mentioning, make best use of their presence. I know you've already got questions lined up for them. They're already geared up, but you'll find as the workshop goes along, their vast knowledge in these areas, particularly of vulnerable witnesses and how the judges should be sensitive to their needs. Thank you very much for all of you participating in today's function. And a very special thank you to Justice Nageswara and Justice Gita Mittal for being here this morning. Thank you.
Thank you, sir, for your valuable insights on the extent of vulnerability when it comes to witnesses and the role of the various stakeholders in their protection. There really can be no peace without justice, no justice without truth, and there can be no truth unless someone rises up to tell you the truth. To facilitate the same to the witnesses in the court of justice, various vulnerable witness deposition centers, virtual courtrooms, and e-filing stations are being opened today in the various districts of Orissa. For this, it is my honor to humbly request His Lordship Honorable Shri Justice L. Nageswara Rao, Judge, Supreme Court of India, to formally inaugurate the vulnerable witness deposition centers, virtual courtrooms, and e-filing stations in the district court complexes of Orissa. Thank you, Your Lordship. We now have a brief videographic presentation of the vulnerable witness deposition centers, virtual courtrooms, and e-filing stations opened in the various districts in Orissa. Thank you. It is my utmost privilege to humbly request His Lordship, Honorable Shri Justice L. Nageswara Rao, Judge, Supreme Court of India, to kindly address the gathering and deliver the keynote address. Your Lordship, please.
Dr. S. Muralidhar, Chief Justice of the High Court of Orissa. Justice Gita Mittal, former Chief Justice of the Jammu and Kashmir High Court. Justice Sahu, Justice Rautre, other brother judges and the sister judge of Orissa High Court. Advocate General Ashok Parija, Assistant Solicitor General, resource persons, senior advocates, district judges, public prosecutors, and judicial officers. Good morning. It's a great honor that is conferred on me by Justice Muralidhar to be here to inaugurate the vulnerable witness deposition centers in the remaining districts of Orissa, as well as the e-filing centers. I've known Justice Muralidhar for about 27 years. I shifted to practice in the Supreme Court in '95, and I've been seeing him since then. He had his heart always in the right place for the deprived sections of the society. You must be knowing that he wrote a book when he was a practicing lawyer, Law, Poverty and Justice, where it deals with access to justice and the need for providing access to justice for those people who are underprivileged and who do not have a facility of approaching justice. That apart, as a lawyer, I appeared before him in the Delhi High Court, and his was one of those courts which was a paperless court. He and Justice Ravindra Bhatt were the two judges who were having paperless courts then. And thereafter, I interacted with him, and then we were discussing about the use of ICT in courts. Delhi High Court is much more advanced in terms of e-filing in comparison to the Supreme Court also. And the good work that he has done in the Delhi High Court, I think he has started doing it here in Orissa, and all of you are fortunate to have Justice Muralidhar as your Chief Justice. He is not only a dreamer, he is an achiever. I used to come here on work. I came here a number of times to argue matters in Orissa High Court. I'm going to see the High Court. He must have definitely changed the shape of the High Court as well. I saw a video when I participated virtually in a program where the court-annexed mediation center was started. And soon thereafter, we started an international arbitration and mediation center in Hyderabad. I should tell him now that we took tips from the video for the purpose of providing the facilities for the center in Hyderabad. I'm very impressed with what Muralidhar has done in providing such infrastructure for the state of Orissa. And this would definitely go a long way in achieving whatever he has been dreaming about. Coming to this workshop for these members of the subordinate judiciary, all of you might be knowing that an accused has a right of confrontation of the accuser. This is an age-old principle, even in Roman law. The accused had a right to say that I want to see face to face with the accuser, and the accuser has to tell him about what he has done. It developed into a common law principle. And thereafter, it was also included in the 6th Amendment to the US Constitution, where an accused had a right to cross-examine witnesses. It's also part of the due process clauses in the American Constitution, the 5th Amendment, as well as the 14th Amendment. Insofar as our country is concerned, Article 21 gives a right of a free trial to an accused, free and fair trial to an accused. Provisions in the CRPC give a right to the accused to have proceedings in open court, and also a right to cross-examination. There are certain exceptions that are carved out in the CRPC. What about the rights of the victim? Article 21 is a triangulation of rights. You have the right of the accused, you have the right of the victim, and you have the right of the society as well. The right of the society is to see that the guilty is punished. And the right of the accused is to have a fair trial before being punished. And the right of the victim is also to be taken care of, which is very important. That is, a right to have free space for himself or herself to depose in court. It's not a problem that is confronted in India alone. There have been studies conducted the world over, because even the ICPCR recognizes that the rights of victims have to be protected. Victims, especially victims of sexual violence, they undergo a trauma, and they would be threatened even to see the accused in court. They would not be in a position to depose in a free and fair manner in such a state of mind. For this purpose, there have been various recommendations that are made. Justice Malimat made a recommendation in 2003 that witnesses have to be protected and vulnerable witnesses have to be taken care of. The Law Commission at least had 4 studies conducted, including the last recommendation made by Justice Jagannath Rao, after taking note of judgments of the Supreme Court, as to need for protection of not only vulnerable witnesses, that is the victims, but also providing them a congenial atmosphere for the purpose of deposing in courts. Thereafter, judgments of the Supreme Court. One judgment which I remember of Justice Sikri taking note of the scheme that was formulated by the Delhi High Court. As Justice Muralidhar was saying, Justice Gita Mittal has been taking a lot of interest in this area of vulnerable witness depositions in court. And the programs that were started by the Delhi High Court and the centers that were initiated by the Delhi High Court was to be replicated by all the high courts according to the judgment of Justice Sikri. And thereafter, the recent orders that are passed by the Supreme Court, expanding the scope of the definition of a vulnerable witness, not only to a child who has undergone trauma because of sexual violence, but also persons who are not even children, who are suffering from some mental illness, and even other persons who are not in a position to be giving a deposition freely. So the expansion of the scope of this, I've seen the order. Vibha was arguing that case in the Supreme Court. And the direction given by the Supreme Court that the centers have to be started in all the districts in this country within a period of 2 months. Though there was an order passed much earlier, it took that much time. It's not as if the judiciary can do immediately whatever they're asked to do without the help of the executive. And Justice Muralidhar has been telling me that the executive here has been very cooperative with the court in whatever he has been asking for was given. I think I should thank the executive through the Advocate General for giving all cooperation to the court for the purpose of setting up not only the infrastructure, but also the training programs which are necessary. The order passed by the Supreme Court, I am told by Justice Gita Mittal, has been implemented only in a few states. Delhi has been a pioneer. It's been working extremely well. She has just been telling me about Jammu and Kashmir, where also good work has been done in starting the center. She just told me that today there's some program that is happening in Srinagar. And this might be the only other state where you have these centers in all the districts, where facilities are provided to the vulnerable witnesses, not to come face to face with the accused. We have seen the facilities that are provided in the small video that was shown to us, and also making them comfortable in court. In UK, I was told the judges, they take off their wigs and then they take off their robes to make the witnesses who are coming to court comfortable, and the witnesses are permitted to visit the court much in advance, a day or two earlier. They have their guardian, and they have a person who's going to support them, whose hands can be held by the witness when he or she is deposing. I'm sure all of them are part of the scheme which has been notified in March, the scheme that has been formulated by the Orissa High Court insofar as the centers are concerned. It's all right. Now we have the infrastructure. Now we have to speak about the dramatis personae. It is you who have to run these courts. So that's the reason you have to be sensitized, and you have to be told as to how you proceed with helping these vulnerable witnesses depose freely in court. And that's the reason you have this training program today. You have experts coming from the Supreme Court, Delhi High Court, and the Madras High Court to speak to you, as Justice Muralidhar was saying. These are senior lawyers who are practicing, who have a hands-on feel about what is happening in courts, who will definitely guide you to help these vulnerable witnesses. Slightly different from this, there was a case that came up before me. I was just telling Justice Muralidhar earlier. Sakshi, which is an organization which was instrumental even for these vulnerable witnesses deposition centers, filed a case which came up before me last year, that there are a number of children who have been trafficked and who were also being used as child labor in the northern parts of the country, that is Punjab, Haryana, Rajasthan, etc. And they come from the eastern part of the country, Bihar, Bengal, Assam. So all of them had to go back during COVID. And there were criminal cases that were registered against their employers or persons who were accused of trafficking these children. And it was not possible for these children who were victims to travel from the eastern part of the country to the courts in the northern part of the country. It was becoming very difficult. So the request that was made by Sakshi was that they should be permitted to depose from their own hometowns or towns near the place of their residence through video conferencing. So I appointed Gaurav Agarwal as an amicus and asked him to look into it. And after discussion with the senior counsel who was appearing for the petitioners, he submitted a proposal that we can have some pilot projects where you have remote points, you have the court where the case is going on, that is the trial is going on, and then you have a court where the child is residing, or a court nearer the place where the child is residing. So we had tested as a pilot project cases which were pending in Jaipur, and one of the case in Delhi, I think it was Saket, of children who were deposing from Bihar. So with the assistance of the judicial officers there, we set up remote points, And depositions of these victims and children were recorded, and we found that it was running very well. And seeing that it was successful, we have given directions to the district judges, all the district judges, to have this facility. Wherever it was required, we said that you can permit children who were facing cases in distant parts of this country, instead of traveling, they can depose from there. I was just thinking, with this infrastructure and facility in place, where you have these centers that are established, you don't need to have another infrastructure or facility. That would be unnecessary. I think these centers can be utilized even for purposes other than crimes involving sex, etc. As Justice Gita Mittal was telling me, and the order of the Supreme Court also says that this facility is expanded even to family courts, Juvenile Justice Act cases, as well as Domestic Violence Act cases, and civil matters also. It's not as if it's only in criminal cases that a child needs protection. There might be even domestic violence, where I was just reading a case yesterday evening, which is from the European Union, where a child did not want to see her mother. And after the experience, she was interviewed, and then she was asked, how did you feel seeing your mother in court? She said, it is despicable. I didn't want to see her, and I did not want to even depose in court. So you cannot envisage the myriad cases that might come up in courts. It's not only a question of a minor girl undergoing trauma, but there are various other issues. It's need not be girls. It might be grown-up women also, who might not be in a position to freely depose in court, who might need the protection, and who might need to be permitted to use these facilities. Mind you, you should also keep in mind the accused rights. It's not as if it's only the victim who has to be taken into account. By providing all these facilities to enable the victim or a vulnerable witness to depose freely in court, you should not sacrifice the interest of the accused. His interest also has to be kept in mind, that he should get a fair trial. We are prone to be influenced by the allegations that are made and what we read from the Supreme Court to the magistrate. We are all humans, our minds work the same. Especially when we look into papers in constitutional courts, there might be some repulsive allegations that are made, but we have to definitely try to come out of your human feelings, and then you have to be impartial in judging the accused. You can't be carried away by whatever is said against the accused. You do not know what is the truth, and that's a job that is given to us, to find out whether the allegations made are correct or not. So the need of balancing the rights of the accused and the rights of the victims would become very paramount. That is what trained judges would be doing, and that's what you would be learning now. I was just telling Justice Muralidhar, looking at you, I thought some college students have come here. You're so young. And I'm also happy to learn that there are a number of women judicial officers. I'm sure that the women would be more sensitive to the needs of the vulnerable witnesses. We would be achieving whatever we want insofar as marginalized sections of the society are concerned, which includes vulnerable witnesses, only when we remind ourselves of the duty that is imposed by the Constitution on us, that we have to do justice to all. Thank you.
Thank you, Your Lordship, for your kind appreciation, gracious encouragement, and highlighting the importance of the steps to be taken for upholding and ensuring the rights of the witnesses. As a token of our respect, humble appreciation, and immense gratitude, we would like to present mementos to our distinguished guests to honor their gracious presence in this august gathering. So I humbly request Dr. Justice S. Muralidhar, the Honorable Chief Justice, High Court of Orissa, to kindly present a memento to His Lordship Honorable Shri Justice L. Nageswara Rao, Judge, Supreme Court of India. Thank you, Your Lordships. I humbly request His Lordship Honorable Shri Justice Vibhu Prasad Rautray, Judge, High Court of Orissa, and Member, Vulnerable Witness Deposition Center Committee, High Court of Orissa, to kindly present the memento to Her Ladyship Honorable Miss Justice Gita Mittal, former Chief Justice, High Court of Jammu and Kashmir, and present Chairperson, Vulnerable Witness Deposition Center Committee, Supreme Court of India. Thank you, Your Ladyship and Your Lordship. May I now humbly request His Lordship Honorable Shri Justice Vibhu Prasad Rautray, Judge, High Court of Orissa, and Member, Vulnerable Witness Deposition Center Committee, High Court of Orissa, to kindly propose the vote of thanks.
Honorable Justice L. Nageswara Rao, Judge, Supreme Court of India, respected Chief Justice Dr. S. Muralidhar, Justice Sangam Kumar Sahu, who is present through virtual mode, my esteemed sister and brother judges of High Court of Orissa, Madam Justice Gita Mittal, former Chief Justice of High Court of Jammu and Kashmir, and presently Chairperson of Vulnerable Witness Committee, Sri Ashok Parija, Learned Advocate General, Mr. P.K. Padi, Learned Assistant Solicitor General, all the learned district judges and judicial officers who have joined us in this event, the government officials present, Deputy Commissioner of Police, Cuttack, and other government officials, the President, Secretary, and other office bearers of High Court of Orissa, our dear resource persons, the officers of registry, ladies and gentlemen. Good morning to everyone. Today is a very important day indeed for all of us, as we have with us Honorable Mr. Justice L. Nageswara Rao, Judge, Supreme Court of India, and Justice Gita Mittal on this grand occasion. We feel honored for having been with us Honorable Mr. Justice Nageswara Rao, who acceded to our request to come to Cuttack physically to inaugurate these BWD centers in 15 district courts of Orissa and one-day training workshop for the judicial officers and public prosecutors on the functioning of the BWD centers. His very presence is the reflection of his dedication and commitment towards betterment of the vulnerable groups of the society. It is my virtuous privilege to convey my regards on behalf of High Court of Orissa to His Lordship for gracing this occasion and sharing his ideas. We are greatly encouraged by His Lordship's presence and are immensely benefited by his inspiring words. We are equally inspired and energized by the presence of Justice Gita Mittal for her presence on this auspicious occasion and addressing the gathering on the necessity of BWDC scheme and the guidelines. Her generous presence with us has not only made us proud, but her charismatic words have also infused energy within us to work towards betterment of this vulnerable section of the society. Madam, I express my heartiest thanks on behalf of High Court of Orissa to you for sparing your valuable time amidst your busy schedule to grace this auspicious occasion. I extend my heartfelt gratitude to our leader, our flag bearer, our Chief Justice Dr. S. Muralidhar, without whom this program could not have been imagined of. He is always our guiding force, and it is his endeavor as the leader of the institution in establishing these BWD centers in remaining 15 district courts of Odisha and organizing this one-day training workshop. Truly, as said by my Lord Justice, L. Nageswara Rao. He is not only a dreamer, but an achiever also. My special thanks to Brother Justice S.K. Sahu, the Chairperson of BWDC Committee of High Court of Orissa, and Justice R.K. Patnaik, member of BWDC Committee of High Court of Orissa. I am also equally thankful to all my sister and brother judges of High Court of Orissa, whose kind and generous presence in this auspicious occasion has boosted our spirits. I also express thanks and gratitude to the Advocate General, the Assistant Solicitor General, and all the dignitaries present and government officials whose continuous support made this event successful. I extend my hearty gratitude to the resource persons and experts, Ms. Viva Datta Makhija, Senior Advocate, Supreme Court of India, Ms. Brinda Grover, Advocate, Supreme Court of India, and Ms. Gita Ramsesan, Advocate, Madras High Court, whose valuable insights would be immensely beneficial not only to the participants, but to all of us also. I especially thank each of them for gracing the occasion. I am very much thankful to the office bearers of the High Court of Odisha for gracing this occasion. I also extend thanks to the members of registry, the Director of Orissa Judicial Academy and his team, the CPC and his team, for their untiring efforts to make this program successful. Before parting, I propose vote of thanks to the members of the print and electronic media and to all those who have toiled hard to make this function a grand success. Thank you. Thank you very much all. Jai Jagannath.
Thank you, Your Lordship. I seek the permission of the Honorable Chair in order to declare the event closed. The event is declared closed. I request all the dignitaries on and off the dais and the members of the audience to kindly rise for the rendition of the national anthem.